Welcome. My name is Darshan Kulkarni, and I'm the principal attorney at the Kulkarni law firm. The firm focuses on helping life sciences companies and their service providers comply with a myriad of state, local, and federal laws, regulations, and guidances that apply to their businesses. It's important to recognize that these discussions are not implied or meant to be understood as legal advice and should not be taken as such. Your situation may be different. However, if you believe that you would like specific advice, please feel free to reach out to me via email at darshan@conformlaw.com. That's DARSHAN at conformlaw.com, or by phone at 215-703-7842. Please do not provide any confidential communications, since we have not established an attorney-client relationship, and such a relationship will not be established until we have a written agreement to that effect signed by both of us. The question that we're looking at now is payment via milestones and the impact of that on Medicare and Medicaid. The question that we're asking is, we've set up an arrangement, and will CMS have any problem with the billing as performed? As usual, we're going to go first into the wrong answers and then discuss the right answers. So, will CMS have any billing as performed No, because CMS assumes the best case scenario and will reasonably determine that it has insufficient data to prosecute you. That is not how it's going to work. You can't assume the best case scenario. CMS looks at the data as is available and it doesn't assume anything. So if you got paid, it assumes that you got paid for what would be appropriate, which would include the standard of care. Yes, because milestone payments cannot be billed to Medicare. It's irrelevant whether milestone payments can be billed to Medicare because, again, if you already paid for those services, whether or not milestone payments can be billed to Medicare is not an issue. No, because clinical trials are regulated by the FDA and not CMS. Hence, once the IRB has approved such an arrangement, CMS will not question the IRB's decision. That isn't relevant either, because even though clinical trials may be primarily regulated by the FDA and not solely regulated by the FDA, CMS and Medicare and Medicaid are the payers in certain cases. In this case, we're talking about them being a payer. In that case, whether or not the IRB has approved such an arrangement, the billing is still a concern. Which leaves us with only one option, option number one. Yes, because CMS assumes that you already paid for the standard of care, and that is the correct option. If anyone has any questions, please feel free to reach out to me. Take care. Bye-bye.